Mr Chair, I seek the leave of the committee to move in globo amendments on sheet 032D, and they are amendments 1, 6, 7, 9, 11, 14, 19 and 25 to 29 inclusive.
Is leave granted to move the amendments previously specified in globo? Leave is granted.
Thank you, Mr Chair. Thank you, Committee. I so move those amendments as by leave in globo. The effect of this cluster of amendments is to reserve only to the Supreme Court the capacity for making serious crime prevention orders. At present in the legislation, without a conviction and with a conviction, the Supreme Court may, on the grounds specified in the bill, issue a serious crime prevention order, and the District Court may also make an order post-conviction where a person has been convicted of a serious criminal or serious crime-related activity. So there is the protection that in the District Court it is post-conviction. But nevertheless, we feel that these orders are an innovation in the law. They are quite powerful and very broad-reaching, and until such time at least as there is a well-developed and understood jurisprudence, it appears to us, given the potential for excess or mistakes that occur in all criminal justice systems without there being any intention to do wrong, because all systems operated by people are fallible, we think it would be a prudent course of action to reserve only to the highest court of this state and its justices the capacity for making these highly unusual orders. The further reasons I elaborated upon in my second reading contribution, I won't repeat those reasons here. Mr Chair, I seek the leave of the committee to move opposition amendments numbers 2, 8, 15 to 18 and 22 and 23 on sheet C2016-032D. No. Yeah, 15, 16, 17 and 18. Just to repeat. 2, 8, 15 to 18, 22 and 23.
22 and 23. Is leave granted? Leave is granted.
Thank you. I move those amendments in globo.
Adam, can you just repeat the number?
Yeah.
The numbers are 2, 8, 15 to 18, 22 and 23. And I move them in globo. These amendments together would have the effect of restricting the class of applicants for a serious crime prevention order to the person holding the office from time to time of the Director of Public Prosecutions. And the rationale for this is that, in our view, there should be a distinction between law enforcement agencies whose job it is to identify and apprehend criminals or alleged criminals and to gather the evidence in support of their prosecution or in support of evidence that would lead to them being controlled under this legislation. This legislation, in its current form, allows not only the DPP but also the Commissioner of Police and the Commissioner of the Crime Commission, and we think that is blurring that separation in the law enforcement area. In the British model, as the member for Ku-ring-gai adverted, the class of applicants are the DPP for England and Wales, the DPP for Northern Ireland, the Director of Serious Fraud and the Director of Customs. And as I understand, and my knowledge of English law is imperfect, but those are essentially persons charged with making prosecutorial decisions. They're not, if you like, the cop on the beat, which of course the police commissioner and even the crime commissioner are. So we think it's important, if we are to have this regime of unusual orders with broad and pervasive effects, curtailing traditional legal rights, and I do understand that the objective is to disrupt serious and organised crime, an objective that the Labor opposition shares, but we don't think you should throw the baby out with the bathwater. We think it is important to maintain the structure that currently exists in our system of criminal justice. Police, Crime Commission, they gather the evidence, they apprehend the criminals. It's the DPP who decides when and whether to lay charges or when and whether to seek these pervasive orders. And we think it's important because in the UK context, although not in the legislation, but in the prosecutorial guidelines, it's quite clear that the SCPOs, or as they are known in this bill, are an alternative, a clear alternative to criminal prosecutions. You don't double up. You don't have two hits at citizens, whatever you think they may have done. So we think this is an important safeguard which will not affect the objective or the efficacy of the legislation, but will improve the integrity of the laws and will lead, we think, to increased public confidence in such novel and innovative laws if they're enacted. Mr Chair, I seek leave of the committee to move opposition amendments 3, 10 and 13 in globo.
Is leave granted? Yes. Leave is granted.
I move opposition amendments 3, 10 and 13 in globo. Each of these amendments together would remove the capacity for those named statutory office holders to seek a serious crime prevention order against a person who has been acquitted of a serious criminal offence. As I indicated in my second reading contribution, I think there is something unseemly and unsafe about bringing a criminal prosecution against a person not succeeding, so the person is, in the eyes of the law, not guilty, but still then being able to seek and obtain pervasive orders to restrict their movements and activities. As I indicated, in the UK model and in the Scottish model, the prosecuting authorities essentially make a choice between whether they're to bring a criminal prosecution or, if they do not have the evidence, to seek a serious crime prevention order. We think that's an appropriate fork in the road, as it were, and it protects against the agencies of the state being able to oppress individuals whom they suspect of wrongdoing. We understand, of course, that this does not affect the situation where a person is never charged, and we understand that if you are to have serious crime prevention orders whose objective is to disrupt and interfere with the activities of serious and organised crime, that much of their utility will be in circumstances where you don't have the evidence to bring a criminal prosecution. We think if you're going to have these orders, that's appropriate. But there is, we think, an unsafe and unseemly situation created where, as it were, prosecuting authorities fail in a criminal court but then come back for a second go at a citizen or an individual on the civil basis as provided in this bill. We think there should be a clear choice made by law enforcement authorities about which direction they're going to go in and not have two bites of the cherry.
The parliamentary position.
Mr Chair, I seek leave of the committee to move opposition amendments 4 and 5 in globo.
Is leave granted? Yes. Leave is granted.
These amendments are directed to the definition of what it is to be involved in serious crime-related activity. At the moment, if you look at clause 4 of the bill, it's if you've actually engaged in serious crime-related activity, or so much we can accept, that seems reasonable. But it also extends to the person has engaged in conduct that has facilitated another person engaging in serious crime-related activity. And of course, it doesn't require that you do so knowingly. So a person could, without their knowledge, they could do something that maybe somebody else has asked them to do, with no awareness that it may be facilitating that person engaging in serious crime-related activity. And of course, 4C provides that the person has engaged in conduct that is likely to facilitate serious crime-related activity, whether by the person or another person. So again, it's even, if you like, more tangential. So what those two subclauses B and C do, they really attenuate, they really stretch very thin the connection between what a person might do and actual serious criminal activity. The first category we can understand, that seems sensible and rational if you're going to have a regime such as this. But if you're going to have 4B and 4C, and you're going to expose persons who may do things that they are not aware of that may be contributing to the commission of serious crimes.
We call them innocent things.
If you're going to have those provisions or provisions like that,
Beheading somebody.
then
No.
you should require that they do so with knowledge, they do so knowingly, because then I'm sure it's not the intention of government or those opposite to make people who are truly innocent subject to these serious crime-related orders, because that would be unseemly, that would be oppression, that would be achieving a totalitarian state. Now, you know, I was never a supporter of totalitarian communism. I think that's bad. Totalitarianism of any kind is a bad thing, and this approaches that kind of thing where you don't have the safeguard. And the safeguard should be that if you are going to expose people to these very powerful orders, they must have done something wrong, and they must have done something wrong knowing it to be wrong. You should not catch people who might, at the request of people they know, do things which may contribute to the commission of serious crime, but which they don't know about. For example, driving somebody from A to B at their request when you don't know what they're going to do when they get to place B, or delivering something from one place to another without being aware of what you're delivering. If a person is knowingly engaging in such conduct, then yes, by all means, make them subject to orders of the kind provided for in the legislation. But make sure that there is a level of moral culpability before you subject them to those orders. And that's what this amendment does. It just requires that the person who is to be the subject of an application for an SCPO has done these things knowingly. Mr Chair, I move opposition amendment number 12 on sheet C2016-03 to capital D. I move that amendment. We think it would be a prudent safeguard to make clear that the legislation and that any orders made under it are not inconsistent with the provisions of the anti-discrimination laws of this state. I won't enumerate what those protections are. They're significant matters of record. I know it's not the intention of the government or any agency or arm of government to do the wrong thing, and this would just provide an extra signpost on the road to make sure that any orders sought and granted under this legislation when enacted make sure that those sorts of traditional legal rights are not infringed, or if they are, that it is one of the bases upon which those orders can be reviewed by the Supreme Court in the way provided for by the government in its bill. We think this would improve the operation, the integrity, and we think the public confidence in the regime of serious crime prevention orders, and the government should not be in any way concerned about this or frightened of embracing this protective measure. Mr Chair, I move opposition amendment number 1, which is the only one on this sheet, on sheet C2016-041. Now, I move that amendment. And the reason I do so is that, like the previous amendment, which dealt with the Anti-Discrimination Act, it provides further guidance for the court in making a serious crime prevention order. I'm glad to see the Deputy Premier and the Minister for Justice and Police is here with us tonight, because in his contribution in the other place, the Deputy Premier says we should take comfort in the fact that, although not actually in the legislation and although not actually legally binding in this state, the counterpart legislation has been interpreted by the United Kingdom courts such that, and I quote him, a serious crime prevention order must address a real risk of future offending behaviour. It must be proportionate and commensurate with that risk, quote unquote. Now, as I indicated in my second reading contribution, the reason why the UK courts have formed that view is because of the presence of domestic and European human rights law framework, none of which applies in this state. So, if it's the intention of the Minister and the Government to have the law interpreted in the same way, we need to provide some guidance and some signposts. Now, when you look at the second bill, which deals with public safety orders, there are a series of guidelines or signposts for the police officer in clause 87R, particularly subclauses 2, which sets out a range of things that the police officer must consider in determining whether or not to make a public safety order. And those are good things to have guiding that police officer. But none of those signposts apply to assist the courts in determining whether or not to issue a serious crime prevention order. And what this amendment does is import into the serious crime prevention order regime the same considerations that the Minister and his government thinks should be in the minds of a police officer in determining whether or not to make a public safety order. We started our critique of this set of bills by saying there really shouldn't be two sets of orders. There really should be an integrated single set of orders. But if you are going to have two sets of orders, they should have the same triggers, the same thresholds, and much the same considerations for the decision maker. And we say, if these are the sorts of considerations that a senior police officer should have in his or her mind in deciding whether or not to make a PSO, they should be the same guideposts to assist the court in determining whether or not it's appropriate in the circumstances to issue a serious crime prevention order. We're using the same drafting the government's used, the same notions for PSOs. We're saying it should apply to serious crime prevention orders as well. And we think having that commonality of thresholds, themes and signposts would not only improve the operation but the integrity and the public acceptance of these two highly unusual sets of provisions. So I would urge the government to embrace this constructive proposal from the opposition. Mr Chair, I move opposition amendment number 16 on sheet C2016-032 capital D. This deals with the hearsay evidence. Clause...
Sorry, this is on 032D?
Correct.
And you're moving opposition amendment number 16?
Correct.
On my reckoning, you moved that in your second group of amendments.
Oh, yeah? Okay, that's fine. Yep, that's good. Yeah. So we're up to number 20 then?
Yeah, 20, yeah.
This is about... I move opposition amendment number 20 on sheet 032 capital D. This is to make clear that the legislation in providing for serious crime prevention orders does not intend to infringe against the traditional presumption against self-incrimination. At the moment, if you look at clause 6 of the legislation, it provides for what may be in the content of serious crime prevention orders, but it says in subsection 2, a serious crime prevention order cannot contain provisions that require a person to answer questions or provide information orally. And there are other matters there dealt with as well. But there's nothing to prevent a serious crime prevention order directing somebody to provide certain answers in writing, apart from the other exceptions such as legal client privilege, protected confidences, if you're involved in banking businesses and the like. And so we assume it's not the intention of the government to abrogate the protection against self-incrimination. And we note, of course, that this regime is not criminal in nature. And when you look, for example, at the extreme powers granted to the Crime Commission under the Crime Commission legislation, or to the Independent Commission Against Corruption under the ICAC legislation, the right to avoid self-incrimination is dealt with in this way. A person being asked the question may object. They still have to answer, but any answers they give cannot be used in a criminal matter against them. And so that makes it quite clear that ultimately the objective of the protection against self-incrimination is still preserved, balanced out with the public interest of getting the information. Now here, the public interest, if you like, is to disrupt serious and organised crime. We understand that, but we assume that it's not the intention to abrogate the right to protection against self-incrimination. And if that is indeed a correct understanding, because that protection is imperfectly preserved in the drafting, Amendment 20 is necessary to ensure that a person's rights in that respect are not abrogated. Now, if the government, of course, stands up and says, no, in fact, we do intend to abrogate the protection against self-incrimination, we do want to be able to require people on pain of criminal prosecution, a $33,000 fine and up to 5 years in jail for not telling us everything we want to in writing, well, let them say so clearly, explicitly on the record. But the drafting of the bill does not properly protect people from self-incrimination or being required to self-incriminate in the way I've outlined. And so we say, if that's not your intention, embrace our Amendment 20. Mr Chair, I move opposition amendment number 21 on the same page, on the same sheet. This deals with ensuring that serious crime prevention orders cannot prevent non-violent advocacy, protest, dissent or industrial action. Now, in the current drafting of Schedule 5, Clause 87R, there is a range of matters that the police officer must take into account in terms of whether or not to make a public safety order. One of them, of course, provided for in 87R2C, is if advocacy, protest, dissent or industrial action is likely to be the primary person for the person of persons or persons to whom the order will apply being present at the relevant public event or premises or other area, and the public interest in maintaining freedom to participate in such activity. So it is a factor that the senior police officer must bear in mind. And then it says in subsection 3, however, senior police officer must not make a public safety order that would prohibit a person or class of persons from being present at any public event, premises or other area if the officer believes that non-violent advocacy, protest, dissent or industrial action is likely to be the primary purpose for their presence at the public event or premises or other area. So it rests very much on what the officer believes. And of course, as outlined in the second reading contribution, once made, except where one of these orders is more than 72 hours in duration, it cannot be appealed to or reviewed by the Supreme Court, or indeed any court. And so, and there is no capability or facility for reviewing, scrutinising or evaluating the information or the basis upon which the senior police officer forms the view that a public safety order needs to be made or should be made. So we think, of course, the appeal rights should be liberalised, and of course,
Yeah.
we'll come to that. But we also think that for serious crime prevention orders, similar to the public safety orders, that they shouldn't be a backdoor mechanism to interfere with the ordinary rights that people in our society have to engage in activities which at present is lawful, such as non-violent advocacy, protest, dissent or industrial action. We think those are very important matters in civil society. We had a very extensive debate on those matters in the recent debate on the government's anti-protest laws. Now, I'm not suggesting necessarily that the government is seeking to use serious crime prevention orders or indeed public safety orders as a backdoor method to confront environmental activists, people struggling for better workplaces, people seeking to protect the environment, or simply to, by demonstrating, to raise public awareness of what they regard as important issues. Again, we understand that there may well be a role for unusual and pervasive methods such as serious crime prevention orders, but they have to come with proper checks and balances and safeguards. And again, if it's not the intention of this government to crack down or interfere with people's ordinary civic rights to demonstrate, to protest, to raise consciousness about issues, to take public action, to publicly dissent, or, in the workplace context, to take industrial action, pursuant, of course, to other laws, then that should be spelled out with clarity in the legislation to ensure that fallible humans operating the system of serious crime prevention orders in their excitement and their zeal to protect the community from serious and organised crime don't go too far. And so we would urge honourable members to support this amendment. And of course we have a parallel amendment for the other bill to ensure that these important civic rights are protected. You take it correctly. I do move opposition amendment number 1 on sheet C2016-040. Mr. Deputy President, well, Mr. Chair, in this capacity, this is a direct challenge to the government's bona fides on this bill. Now, once a serious crime prevention order is made, it's of course an offence to breach that order, punishable by up to $33,000 against a person, or $165,000 against a corporation, or in the case of a natural person, up to 5 years in jail.
Order. Could people just keep the level of conversation down?
But, of course, and both of the bills before the House are common in this respect, there's no defence provided for in the legislation. And because the government has borrowed from the 2007 UK Serious Crime Act, I had a look at that provision, that legislation, to see how the originators of this regime dealt with the situation. And lo and behold, Section 50 of the UK Serious Crime Act 2007 provides for a defence to a breach of the legislation, in exactly the same terms as those which I propose here tonight. So if this government is serious about the UK model, which they say is fair and reasonable and balanced, and they say is necessary, well, let's adopt all of it. Let's not just cherry-pick the bits that we like, the bits where the rights of citizens and non-citizens alike are thrown out the window, but let's also provide the whole package. Let's provide the whole package, including this. And it's a real challenge to the bona fides of the Minister and of the government generally about their intentions with this legislation. It would have been an easy thing for us to simply say, this legislation is very bad, it's very poor, and shouldn't be supported. But as a responsible opposition, as the alternative government, we've engaged with the very serious public policy issues, and we are doing our best to take a bipartisan or cross-partisan approach to these issues, to improve the bills so that we have not just a vigorous and robust series of anti-crime measures, but we have them with safeguards and where the integrity and public confidence in the provisions can be improved. And this is one of those measures. This is one of those measures. If the UK model is so good that they've borrowed from it, let's take all of it. Mr Chair, I move Amendment 24 on sheet C2016-032 capital D. This deals with appeals against serious crime prevention orders. Of course, the government does have in the legislation an appeal mechanism found in clause 11. And in this respect, it's much better than the counterpart bill, which has an appeal mechanism that no one will ever be able to use. However, the appeal is restricted, as we see in clause 2, to an appeal as of right on a question of law, which is fine, and with leave on a question of fact. And we think that's too narrow. We think a better mechanism is a rehearing as provided by Section 75 capital A of the Supreme Court Act. Otherwise, the appeal provisions are fine, but we think the appeal mechanism just needs to be made a little bit more flexible than the somewhat narrowed version that we currently have in the bill before us. I take it we're now moving to Schedule 5.
Yes.
And I seek leave to move a series of opposition amendments on sheet C2016-034 capital D.
Yep.
And those amendments are 1 and 14 to 22 inclusive.
1, 14 to 22. Is leave granted?
Not all of them, but a lot of them.
2 to 11. I think we can proceed on the basis
For that bill.
Leave is granted.
Thank you. I move opposition amendments numbers 1 and 14 to 22 inclusive. These provisions, or these amendments together, would provide a meaningful avenue of appeal from the making of public safety orders. In the legislation as it's currently drafted, while there is an appeal mechanism, it can only be utilised in relation to public safety orders made that are more than 72 hours in duration. And I refer to Division 3 and clauses 87V, W, X, Y and Z in the bill. If a public safety order is less than 72 hours, there appears to be no mechanism in the legislation for a person subject to such an order to approach the Supreme Court, or indeed any court, to have the order reviewed or put aside. Now, it's an interesting approach because in relation to the making of serious crime prevention orders, the government says, well, the courts should make this order. It's so serious and important that the courts should make this order. But the public safety orders in the second bill are in many ways more powerful and more pervasive. And yet these are able to be made in this bill, not by the leadership of the police force, by police officers of the rank of inspector and above. And they're termed senior police officer in the bill. But of course, and I stand to be corrected, and if I'm wrong, no doubt the Honourable Parliamentary Secretary will pick me up, but I think an inspector is the lowest rank of commissioned police officer in this state. So without wishing to cause any disrespect to persons of the rank of inspector, relatively speaking, they're not senior police officers. And this legislation would give persons of that rank and above enormous and pervasive powers to determine whether or not persons can present themselves at certain places at certain times or not. And the regime all rests on a view formed by the police officer, a view which might be right or it might be wrong, but certainly it can't be reviewed, it can't be scrutinised or evaluated, because a person who is to be subject to it won't get notified that the police are considering making an order. They won't have the right to be heard before any order is made, they're bound from when they're communicated, when they're presented with a copy of the order, or in the case of urgent orders, when they are when they have the order communicated to them in the terms provided for urgent orders in 87 capital T, and of course in the other provisions. But we think it's important to have a proper appeal mechanism. If you're going to have such serious restrictions on people's liberty and their right to be places and to do things, then the least the Parliament can do is to provide a meaningful appeal mechanism, because in a sense what we have here is a complete joke, because on one view of it, well, the appeal mechanism only applies to long duration public safety orders, and I think it might be an error of drafting, or maybe I haven't read it properly, but I can't actually see how you can make a public safety order more than 72 hours, because I think if you look at the provisions, in particular clause 87 capital S, I think it's only possible to make them of 72 hours or less. So what we have here is in fact an elaborate charade. The government presents the bill saying, "Oh, don't worry, there's court supervision here. If you don't like it, you can appeal in certain circumstances." But this appeal mechanism cannot be used. And of course, as we know from the very informative briefing provided by the Justice Department, for which I thank the Police Minister, there is nothing in the bill to catch a situation where consecutive orders are made against a person, all of which are less than 72 hours in duration, but which have the effect of restricting a person's movement and activities either every Friday or every Saturday, or indeed each day of the week. As long as they are separate and distinct orders, there is no general provision that wraps them all up, such that if the police exceed bringing orders against a person exceeds the 72 hours, because that 72 hours only applies to an individual order, not to a consecutive series of orders. So, as I read the legislation, the police, if they're really concerned about someone and their activities, could actually have a series of orders against a person which amount to hundreds of hours, and never is the person able to have those orders appealed to or reviewed by the Supreme Court. I don't wish to be conspiratorial, but that was the clear advice of the departmental officers, that could happen, and that the appeal mechanism would never be engaged. And if that's right, we have an appeal mechanism that's designed to have no work to do and to never be used. So we have these very powerful orders that the police, relatively junior police, can issue against a person based on that police officer's belief, which may be right or may be wrong, but certainly can't be scrutinised or reviewed, and there's nothing the person subject to it can do. Now, I understand the objective is to ensure public safety and reduce the criminality and activities of criminals, and that's the laudable aim and one in which the opposition shares. But again, if you're going to have these novel and powerful orders that can be utilised, and they're issued by the police, not by the courts in this instance, they must be able to be reviewed by the courts. And there is no effective appeal mechanism or review mechanism in this bill, and there should be. I move amendment number 2 on sheet C2016-034 capital D. This amendment would restrict the police officers who could make public safety orders from the present cohort of inspector and above to only the commissioner, the deputy or assistant commissioner. We propose this amendment as a safeguard. We think the rank of inspector is too low to be making such an important and powerful set of orders. If such orders are to be available to the police to assist with dealing with or preventing criminal activity, it should be reserved only to the most senior members of the police force. The reasons for this I elaborated on in my second reading contribution. I won't repeat those matters here. Mr Deputy President, I seek leave to move opposition amendments numbers 3, 5, 7, 9 and 13 in globo.
Sorry, that was 3, 5, 7, 9 and 13?
Correct.
Is leave granted? Yes. Leave is granted. I don't know if yours actually counts. Leave is granted.
Mr Chair, at the moment that we think the threshold for making a public safety order is too low. At the moment, it's triggered by a senior police officer's concern that there may be a risk to public safety and security, which, as defined in the bill, covers all manner of ills from property damage at the low end through to the serious injury or death of another person at the high end. So it covers quite a broad range of potential ills, and having it reach so low down as to be triggered by property damage, for example, given the pervasive and powerful nature of these orders, we think a more restricted range of issues only should be able to be dealt with or triggered by public safety orders. And again, we don't understand why there are different thresholds and triggers and rules to apply to public safety orders as opposed to serious crime prevention orders. We think the trigger for each should be essentially the same. We have argued for a single regime of orders, and therefore we think the legislation should be amended so that a public safety order may only be triggered by the apprehension that there is serious crime-related activity as provided for in the other legislation, so that there is greater consistency between the two new laws to make sure that that the legislation is really directed at very serious matters that warrant the exceptional measures which are under consideration by the Parliament. Having public safety orders being used to deal with property damage would seem to be excessive in our view, and it should only be really serious criminal activity that should be the subject of either regime of orders. Thank you, Mr Chair. I seek leave to move opposition amendments numbers 4, 11 and 24 together.
Is leave granted? Leave is granted.
These amendments would prohibit the making of a public safety order against children or other vulnerable persons as defined in a proposed new clause 87Q, which would be persons who are under the age of 18, persons who have impaired intellectual functioning, and persons who have impaired physical functioning. Now, we understand that there are intended to be differences between serious crime prevention orders and public safety orders, but we do note that the serious crime prevention orders only apply to persons who are aged over 18. They only apply to adults. And we haven't heard from the government any substantial rationale as to why the pervasive and strong powers provided for in connection with the proposed public safety orders need to apply to children or should apply to persons with impaired intellectual or physical functioning. We note that there are special provisions for those persons in 87 capital T 2 and 3, but notwithstanding the reasons advanced in support of public safety orders, the government has not explained why it is necessary to have these vulnerable persons able to be subject to these orders. We think that is extreme. We do not see the rationale for it, and we ask the government to accept our amendments. It cannot be the case that it is necessary to have these orders in connection with these persons. There should be this small group of persons carved out, as persons under the age of 18 are carved out from the application of serious crime prevention orders. And of course, it should be remembered that the serious crime prevention orders are very pervasive and not only go to persons who are directly themselves engaging in serious criminal or crime-related activity, but persons who are facilitating or are likely to facilitate such activities, whether or not they're even aware of it. So if that extraordinary regime doesn't apply to people under 18, why then should this? We just think it is just an overreach, and the Parliament should ask the government to just take one step back and to provide this, we think, small but important safeguard. Mr. Chair. Mr. Chair, I note the comments from the Parliamentary Secretary about the safeguards in place for vulnerable persons. But of course there's a fundamental flaw with his analysis and his commitments to the House. There's no review mechanism. Let's suppose that all of these are not complied with substantially, or the reasons that are advanced in the notification to the parent or guardian are completely fallacious and spurious. It doesn't prevent the order from being made. It's a non-safeguard because there is no capacity to review it or to have it reviewed by a court. Because you see, if you look at 87T2, it says if the senior police officer considers the person to whom the order applies is under 18, they must ensure the order and notification are also served on a parent or guardian. Well, so what? So instead of just being served on the person, you go to the parent or guardian. So the parent or guardian of the physically or intellectually impaired person presumably then has to have the shared responsibility of making sure their child or the person they're the guardian of doesn't breach the order, if of course it's reasonably practicable to do so. And these safeguards are merely a notification in writing specifying dates, setting out the reasons. Doesn't mean the good reasons have to be good or cogent or sound or rational or based in fact rather than prejudice or supposition or completely erroneous material, because there is no rigour, no probity and no discipline in this reset of regime, this regime of orders, because no one can review it. Another copper could, of course, same copper, more senior copper, but there is no independent scrutiny by the courts, which means, human beings being what they will, there is a serious risk of laziness, of making decisions on a weak basis or premises. And of course I know that the police are dedicated to protecting the public, and they will err on the side of caution, of not taking risks. And therefore the absence of supervision by the courts of police actions in this regard is a serious failure in the regime proposed. And I don't say this by way of criticism of the police force or its members, but it is the government, and if allowed to stand, this Parliament, which is letting our serving officers down by not providing a proper systemic support for the role they will play in determining whether or not to have orders and in what terms. It actually would assist the police force in the execution of their duties to have that independent scrutiny, to provide them with that additional support and rigour, and to provide integrity to the scheme. it is vitally important that when we enact unusual measures like this with the objective of protecting the public, that we don't unwittingly create a situation where members of the public are themselves adversely impacted. And I think when we're dealing with young people and people who are impaired, whether intellectually or physically, special care needs to be taken. And with all due respect to the Honourable Parliamentary Secretary, the bill in its current form doesn't do that. The mere obligation to provide additional notifications to additional people containing information doesn't actually, with respect, protect those persons. People with intellectual impairments may not fully understand the terms of the order that they are subject to. The mere fact that it's served on their guardian or parent, who no doubt will do their best to ensure their child or ward doesn't breach the terms of the order, it's a bit hard to make sure that happens. This is an extremely unrealistic and very dangerous proposal if we do not take the precautionary step pleaded for by the opposition. We really ask you to embrace this, not to weaken the regime, but to strengthen it, to give the public greater confidence that there will not be excess or overreach or innocent people adversely impacted. I move Opposition Amendment number 6, which provides that a senior police officer must not make a public safety order unless the person has been given a reasonable opportunity to be heard about the order. This meets one of our criticisms that people are not being given won't be given the opportunity to be heard before the police officer makes an order. Of course, the assumptions on which the police officer is acting or will act will never be the subject of review, will never be tested on the way through. It seems an extraordinary proposition that such powerful orders would be able to be made restricting people's right to go places at certain times, to do things and be at events or in locations without even being able to be heard on the matter. And at the very least, people should be given the opportunity to be heard by the police officer before such an order is made.
Adam Searle.
Mr Chair, now I seek leave to move Opposition Amendments 8 and 10 in globo.
Is leave granted?
Yes.
Leave is granted.
I move Opposition Amendments 8 and 10 in globo. These address themselves to ensuring that public safety orders cannot be used as a method to prevent non-violent advocacy, protest, dissent or persons engaging in industrial disputes. I know those matters are adverted to in proposed clause 87R subsection 2C and 3, and indeed a senior police officer is enjoined to not make a public safety order if the officer believes that non-violent advocacy, protest, dissent or industrial action is likely to be the primary purpose of a person's presence at the event or premises or other area. However, the problem with the safeguard, if it be a safeguard, is that it rests on what the police officer believes. If the police officer believes that those gatherings are really for the purpose of engaging in one of the things that are prescribed by the legislation, damage to property, destruction to property, serious injury or death or any of those things that are included in the definition of a serious risk to public safety or security, if the police officer believes that's likely to be the primary reason, then they may still make a public safety order, notwithstanding the fact that the actual and real and substantial reason for persons gathering together is in fact for those other lawful purposes of non-violent advocacy, protest, dissent or industrial action. Now, we've debated at length not so long ago the anti-protest laws, which many persons in this chamber and the wider community felt were an unwarranted infringement of people's existing rights in a civil society to engage in those activities. Indeed, ensuring that there is proper space for those activities is a cornerstone of our democracy. Now, I'm sure it's not the intention of the government to, through the means of public safety orders, infringe those rights. but such protections as are sketchily provided in existing clause 87R do not provide the necessary guarantees in our view, and so we propose amendments 8 and 10 to put the matter beyond doubt.
The Parliamentary Secretary.
Mr Chair, I move opposition amendment number 12, which would ensure that any order made under this legislation would not be able to contravene the Anti-Discrimination Act. Mr Chair, I move opposition amendment number 23, which would provide a defence to a person facing a charge for breaching a public safety order and provides a statutory basis for a reasonable excuse to defence for contravention. It's similar in its intent to the amendment we moved in relation to the Serious Crime Prevention Orders Bill. It would put on a clear statutory basis that there is a defence to a breach of the legislation, to a breach of a public safety order. I apprehend that the government's going to say, well, this right exists anyway, even though it's not in the legislation.
Not be too sure about that, Adam.
Well, I'm not too sure. And again, I invite the Parliamentary Secretary to show me where it is. I'd be very happy to be wrong about that. But more interestingly, perhaps of more interest to more members, would be if the Parliamentary Secretary could outline the legal basis upon which he says the defence exists independently of it being in the legislation, just so we can have more comfort that the government's not going to accept this amendment. Because if it is in fact the government's intention that there would be a reasonable excuse defence for breaching a public safety order, and there is a sound legal basis for the government having that view, well, I for one would be content. But I'd like to understand where such a defence would arise. It's the case that even in relation to minor criminal offences, the reasonable excuse doesn't apply any longer, having been abrogated by those offences taking statutory form and no longer being common law. Now this is a statutory regime. I'd be interested to understand how what was a common law defence would apply to a new statutory provision such as this.